Donald Trump's legal battles are escalating. The clash over those controversial deportation flights may be headed to the Supreme Court. Trump has asked the justices to greenlight deportations under the Wartime Alien Enemies Act. We'll have more on that later this hour. But first, two more law firms are fighting back against the president in his legal vengeance tour. Jenner & Block and Wilmer Hale are suing to stop executive orders aimed at hindering their ability to represent clients. The executive order would strip lawyers at both firms of security clearances and bar them from entering federal buildings. The firms are being targeted for their civil rights and immigration pro bono work, as well as their ties to special counsel Robert Mueller, who led the Russia investigation during Trump's first term. Jenner & Block called Trump's order, quote, an unconstitutional abuse of power. And according to the New York Times, a, quote, split is emerging among big law firms, with some firms fighting back while others are bending the knee to Trump. Today, Trump announced a quote-unquote deal with top law firm Skadden Arps. The administration had not issued an executive order targeting that firm, but the New York-based firm nonetheless entered into what the president called a settlement, in which it agreed to undertake $1 million in pro bono work on behalf of causes aligned with the administration.
We appreciate Skadden's coming to the table. As you know, other law firms have likewise settled the case, and it's a shame. What's gone on is a shame, but we very much appreciate their coming to the table.
Trump knows exactly what he's doing. He is weaponizing his executive power to target law firms that he views as enemies, and that might be in a position to underwrite challenges to the administration going forward. Not only do these law firms undertake their own pro bono work that often challenges the government, they also critically assist nonprofit groups that do the same. These executive orders are aimed at silencing law firms and, in the process, cutting off much-needed avenues of support to nonprofits that are challenging the administration. Trump is also exercising his muscular vision of executive power in the immigration space. He is preying on the vulnerable non-citizens to make a statement. ICE has continued its crackdown on college campuses. Just moments ago, a judge blocked the government from deporting Tufts University PhD student Rumeysa Öztürk, a Turkish national, after this disturbing video showing her arrest sparked outrage. DHS, she alleged, engaged in activities in support of Hamas. So far, we have not seen any evidence of that. What we do know is that Öztürk co-wrote an op-ed criticizing the university's response to student protests and demanding its divestment from Israel. All of this comes on the heels of a judge ruling the Trump administration must stop its efforts to deport a Columbia student who participated in pro-Palestinian demonstrations. The record here shows that the Trump administration is losing. In the courts this week alone, he has seen exponentially more losses than wins. To discuss all of this and this escalating situation, joining me now is Christy Greenberg, former federal prosecutor, SDNY Criminal Division Deputy Chief, and an MSNBC legal analyst. Alongside Christy is Jamil Jaffer, the executive director of the Knight First Amendment Institute at Columbia University. He is currently representing a group of professors who are suing the Trump administration over the administration's attempted deportation of university students. Christy, let's talk about the law firms for a moment. I was really interested in the president's use of the term settlement. We typically hear in legal circles settlements when you actually have a case where both sides are negotiating over this. But here it seems the law firms actually have a really good case to make. They have a First Amendment right to take on certain clients, to make certain claims. They may not necessarily have a right to security clearances, but as to the rest of the work they do, it seems like they have pretty settled law on their side. Why are they then caving to the administration?
Money. They know that if they are not in favor with the Trump administration, it could mean clients going to competitors. And at least some of the firms will say that this affects their ability to survive. I don't know whether that's accurate, but You know, at the end of the day, it is so important for the law firms that are fighting, because there really is strength in numbers. If all of these law firms really banded together, it would be that much harder for these clients to say, well, we'll just go somewhere else. We'll bring our business somewhere else. Or that much harder for these partners to find another law firm to go to. Strength in numbers matters here. And I will say, like, the settlements that have been reached, you know, you'll have a firm like Skadden.
Oh, should we call them settlements?
It's more bending the knee. The deal,
the art of the deal.
That's more accurate. Of saying, well, we'll just do this pro bono work that we were already doing anyway, and we'll just do this work, and that's pretty innocuous. But it's not, for two reasons. One, you know, you are agreeing to do certain kind of work that only is going to be work that the president approves of. That's troubling. And also, implicit in that is that you're not going to take on certain work that the president is not going to approve of. I think back to when I was a first-year associate at a top law firm in Manhattan, and I worked for a year exclusively on a case pro bono where we represented a class of African Americans and women in Alabama who were being discriminated against in hiring and promotions for those positions. That was a 30-plus year consent decree. And at various times, the Department of Justice did not like this case. They were consent decrees in the civil rights realm were not really in vogue. And yet, at no point did the law firm waver and say, well, we're not going to commit to this anymore. They stuck with it. And at no point did the DOJ put any pressure on the firm not to. So it's important that these law firms take pro bono cases because they believe in them and not because it's being dictated to by the administration.
So this is a really great point, Jamil, and at least some of the law firms are standing up, even if they aren't all standing up collectively. The law firm WilmerHale filed their lawsuit against the president today, and in that complaint, they note, quote, the First Amendment protects the rights of WilmerHale, its employees, and its clients to speak freely, petition the courts and other government institutions, and associate with the counsel of their choice. What's the strength of their case here? Is this a slam dunk for them?
Watertight. I don't think there's any question at all that the First Amendment protects these law firms. Jenner will win, WilmerHale will win, and Paul Weiss and Skadden would have won had they sued. You can understand, I think, if you think about these issues from the perspective of any individual law firm, you can understand why this is so difficult. It's very difficult for any specific law firm to stand up to Trump on its own. But I think Christy's right. It's really about collective action. Like all of these law firms need to stand up. And if lawyers can't stand up for the rule of law, I think, you know, all is really lost.
So this seems to be a problem of collective action, Christy. So in the case of Paul Weiss, for example, the New York Times reports that there may have been some kind of law firm arbitrage with firms trying to exploit Paul Weiss's vulnerabilities during that period. What are the pressures that the firms face, and why can't they stand together, especially given that a lot of the work that they're doing is actually supporting nonprofits who are not going to be able to take on this administration alone?
I mean, the reporting suggests that the law firms are concerned that their clients will leave. The clients have told them, hey, we can't stick with you even though we may agree with you. We can't stick with you if you take this position. That very profitable law partners would leave the firm. And again, that's why collective action is important, because if everybody's banding together, there's nowhere else for those big clients and those big partners to go. And again, when you have these orders that are so blatantly constitutional, that violate the First Amendment, that violate the Fifth Amendment, there's not the process that's needed here, and that violate the Sixth Amendment, you know, the right to be able to choose your own counsel and not have that choice dictated to you by the administration and it so violates the separation of powers. And, you know, the president doesn't get to just make up the law. Like, he's there to enforce the law, but I mean, he has no authority to be doing this. It's such a violation. And it really does. I thought the brief that was done by Paul Clement, when he says in the brief, like, listen, you can't dictate what we're doing here. And usually discovery would be required to find out why this was happening. But you actually say in the order that the purpose is to retaliate and to punish these law firms. And that is so blatantly unconstitutional on its face.
We should say for our viewers that Paul Clement is a very prominent appellate lawyer. He's the former Solicitor General under a Republican administration, and he is representing one of the law firms that has stood up to these orders. Jamil, you are involved in a case where you were fighting the Trump administration over student deportations, and you make an actually quite unusual or unorthodox argument that there is a right of American citizens to hear these perspectives of foreign nationals in these graduate programs, in the academic environment. And so these deportations are actually a violation of the rights of American citizens. Why did you choose this argument?
Well, so first of all, we do argue that the deportations, the arrests and deportations of students are a violation of their rights. We make the argument that the government doesn't have the authority under the First Amendment, or the First Amendment restricts it from arresting and deporting people on the basis of viewpoints that the government doesn't like. But we also argue, as you say, that these arrests have implications for American citizens as well. And the plaintiffs in our suit are associations of university professors who assert that their American members are injured by the arrest and deportation of the students. And the complaint actually describes what the professors call a climate of fear and repression on campuses across the country, with non-citizens stepping back from political advocacy, not going to class or not participating in political conversations, not being willing to share political speech online or even in private texts. And really, a lot of foreign citizens, faculty and students alike, are terrified that ICE agents are going to show up at their door tomorrow because they participated in activity that is protected by the First Amendment. So it's really, quite a dire situation. I don't think there's any precedent for it in recent American history. It's the kind of thing that you would expect to see in the most repressive regimes, in Egypt or in Turkey, people being picked up, put behind bars on the basis of lawful political speech.